Welcome to the WRAL Daily Download. I'm Jack Hagel. A closely watched North Carolina legal battle heads to the U.S. Supreme Court today. It's called Moore v. Harper, and the case focuses on who has the authority to set when and how elections are conducted. And it's received a lot of national attention. Some legal experts say it could fundamentally change American democracy. We've been focused on the case all week on the Daily Download. On Monday, we had an overview of the case with WRAL state government reporter Travis Fain. And yesterday, we heard from people on both sides of the argument. Be sure to check those out. Today, we're going to start with WRAL Capitol Bureau Chief Laura Leslie. She'll be in Washington at the Supreme Court reporting on the arguments. Later in the episode, we'll hear from Michael Bitzer. He's the author of Redistricting and Gerrymandering in North Carolina, Battlelines in the Tar Heel State. Laura, good to see you.
Good to see you.
So first, a quick rundown of the case, and I've been asking people this question all week, and I've gotten a variety of responses, so it's your turn. What is this case about?
Well, on its face, the case is about redistricting, right? And that is what the plaintiffs in this case, the move-ins, the petitioners, Moore, et cetera, insist that is all that it is about, is the issue of drawing lines on maps. But people on the other side and a lot of legal experts around the country say that what it's at the core, what it's about could go a lot farther than just district lines. It's time, place, and manner of elections. And that could include a whole lot of different laws and possible restrictions on voting, changes to voting laws, basically anything that wouldn't be illegal under federal law, the states would be able to do, even if it violated their own state constitution.
So one outcome of this case could be that the legislature in any given state has more authority to define elections, as you described. Does that mean states where legislatures are run by Democrats could see laws that are more favorable to Democratic voters?
Oh, yeah, it works both ways. I mean, absolutely. And some of the Democratic-run states are some of the worst when it comes to redistricting and gerrymandering. So, yeah, this would cut both ways. The only limits on what a state could do would really be perhaps, and there's some argument about this, if there is an independent state commission that has been set up to do redistricting, that might limit some things for some states. There's some question about whether or not those could even stand because they're not creatures of the legislature, if they were a ballot measure, for example. But yeah, this would go across the board. And basically, it would just sort of open the door for carte blanche gerrymandering. It would say, there's no check and balance on this except for the federal law. The federal law doesn't address that. There's no check from the federal court because we knew from the Rucho decision, that was when Justice John Roberts said that the federal court doesn't have a say in partisan gerrymandering either. So there would be effectively no check.
The most recently approved congressional maps, the ones that were used in the most recent election, that yielded a North Carolina congressional delegation of 7 Republicans and 7 Democrats. Now, in a state that is split almost evenly politically, one might say, well, why don't we do that more often? Why don't we? Is there a way to have a body that more evenly represents the electorate in North Carolina?
Well, for one thing, that would take an independent redistricting commission because no matter who's in charge, Democrats in the past, Republicans now, they draw the maps to benefit themselves. And that's just how that works. And no party in charge is going to ever give up that ability. That would just be malpractice, political malpractice. But the question about how evenly split the state is, I think, is a good one. You have a lot of Republican leaders say, and rightfully so, that when you look at the statewide elections over the past, we'll say 5-6 years, you see that Republicans have done a lot better overall. We have not elected a U.S. senator from the Democratic Party since Kay Hagan, and that was on the coattails of Barack Obama in 2008. So, and this year, if you have a look at the judicial races, you take a look at the Council of State in 2020. There are some Democrats, but they tend to be the outliers. So Republicans would say this state is redder. Now, what political scientists like Dr. Bitzer would say is that Republicans do tend to turn out more. And that's really what their secret is. Because when you look at the breakdown of voters, it looks like we're an evenly split state, but the Republicans have the highest level of turnout and the most reliable turnout. And that's one of the reasons that they tend to dominate, regardless of what the numbers look like at voter registration.
Okay, so set the stage for today. What is the Supreme Court doing?
Well, today the Supreme Court is going to come in at 10 o'clock, gavel in. About 10:30, they're going to start hearing arguments from the lead counsel. I think there may be several representing different parties that may speak today, but they'll hear, usually it's about a half an hour per side is the way it works. They've petitioned and been granted 45 minutes per side. It may go a little over, I guess. depending on what kind of rebuttal time is allowed. So, we're expecting some pretty active questioning. There were so many briefs in this case that the judges have certainly had lots and lots to chew on. And I expect we'll hear some rapid fire cross-examination from the bench, from the judges on either side on this one.
So it's going to be a whirlwind, too. How do you prepare for cases like this? It's
hard because, if you think about what happens in a regular court, you pretty much have a whole day of opening arguments, right? And that gives you the chance to sort of hear what the arguments are going to be that each side is going to be trying to develop as the trial goes on. At the Supreme Court, you get about 2 minutes of sort of like top level, here's our case. And then after that, it's straight into questions. And so some of those questions are going to come from the main briefs. Some of those questions are going to come from amicus briefs. And if you haven't read those briefs, you're not going to understand what's being asked, maybe. So one of the real challenges for this case is that there are 60-something briefs. Of course, they're not all going to have equal legal weight, but there are some that I think are probably more useful than others. And so, the question is, which ones do you read? Because I don't know anybody who's not on the Supreme Court who's going to read 65. but yeah, and so hopefully you can kind of keep them straight and remember what, and then when somebody starts asking a question, you'll know kind of what they're talking about.
And you've also been preparing your ears, right?
Yes, because this is a little known fact. So when you go into the Supreme Court, you are not allowed to take any kind of recorder. All you can take with you is your pen or your pad. And they seat you in this press gallery, but half the seats there, you can't see the judges. So basically, it's kind of like listening to the audio stream. And they don't address each other by name very often. So you often have to just figure out who's talking. And so I actually have like a spectrum here of the voices. Like Gorsuch is the lowest. He's the bass. Amy Coney Barrett is the highest. The three other women on the court, Kagan, Sotomayor, and Jackson, have very similar registers. Kagan's a little bit more New York. Sotomayor, Jackson's a little bit closer to medium than low. And then you've got the men. Roberts is right. It's so funny. He's Chief Justice. He's right in the middle. He's really level. And they got Alito, who's kind of gravelly, and he's very expressive with his voice. He's up and down, so that's how you know it's him. Thomas doesn't talk that much, but he has a low voice. And Kavanaugh talks more, and he's also lower than Thomas. So you have to, let's put it this way. I've heard a lot of arguments I don't really care about, but I've been following them along with the transcript to try to train my ears to know which one is which.
What other logistics are you dealing with?
Well, we're dealing with the fact that the Supreme Court is still absolutely positively a print place. You can bring in a pen and a pad. You can't bring in anything to record with. Your photographers can't even come into the building, right? Now, we've all heard Nina Totenberg do her Supreme Court coverage on NPR. And one of the reasons that she's so good at it is that she sort of like acts out the parts of the justices, right? That's because you can't record it, or you weren't able to until there was an audio stream that just happened during the pandemic. But it is really challenging because you got no video to work with. And you also got nowhere to work because the photographer has to be able to plug in their computer. We're out there on the streets of Washington, trying to figure out where you're going to go live from and looking for somewhere to, eat, use a restroom. So it is definitely a marathon of a day. But it's still going to be a lot of fun, I think, to get to go up and see it.
What are you going to be listening for?
Well, I think specifically I'm going to be listening for Kavanaugh a lot because Kavanaugh is sort of the one who did not – okay, so when you think about the fact that legislators asked for the Supreme Court to step in and stay these new maps, there were three that would have given them the stay, and that was Alito, Gorsuch, and Thomas. Kavanaugh did not sign on to that with them. He wrote his own sort of, saying that he would not grant the stay. But then he basically encouraged them to file a writ, of certiorari, so basically saying, bring this back and we have more time to talk about it. And they did. And he has said, both in that opinion that he wrote and in other places, that he is interested in A, the question of independent state legislatures, the theory, and then B, the question of how one reins in courts if there is no check and balance on the court. And so I think that's going to be really interesting. I think we haven't heard a lot from Amy Coney Barrett on this topic. I don't know. I mean, given her background, I'm sure she has some pretty strong thoughts about constitutional law. So I think, I'll be interested to hear what she has to say as well.
Any predictions?
I don't know because, I've heard a lot of smarter people than me who say they don't know. I will say this, I think there's a lot of talk about whether or not they could find a way to narrow this, to tailor the judgment or the decision in a way that would not have big impacts, right? I don't know that that's the case. And I also don't know that that's really what they want, because what Kavanaugh said when he, told them to file a writ of cert, he basically said, this is a legal argument that keeps coming up and we need to hear it out and make some decisions about it. So very smart people like Derek Mueller have said they're probably going to find a more limited way to settle this. I am just not sure whether that's going to satisfy some people on the court, like Kavanaugh, Alito, Thomas, Scalia, who really want to see, not Scalia, Gorsuch, who really want to see the court take some kind of a stand on what this particular clause in the Constitution means.
Well, Laura, thanks for breaking it down for us. Thanks for being there, and good luck today.
Thank you.
That's WRAL Capitol Bureau Chief Laura Leslie. For her coverage of today's arguments, tune in to our evening newscasts and visit the NC Capitol section of WRAL.com. We'll take a quick break, and when we come back, we'll get some perspective from Michael Bitzer. He's the Politics Department Chair at Catawba College and the author of Redistricting and Gerrymandering in North Carolina, Battles in the Tar Heel State. Stick around. Welcome back to the WRAL Daily Download. We're talking about Moore v. Harper. It's a North Carolina case that goes before the U.S. Supreme Court this week. In this segment, we're talking with Michael Bitzer. He's the Politics Department Chair at Catawba College and the author of Redistricting and Gerrymandering in North Carolina, Battlelines in the Tar Heel State. He joins us virtually from Salisbury, North Carolina. Professor, welcome.
Good to be with you.
Now, we've heard from folks on both sides of this case, and I'm curious to hear your perspective as someone who has studied this issue closely and isn't directly involved in the case. What does this case represent, and what's really at stake?
I think ultimately what is at stake and what this case is all about is governing power and who has power to do what. I mean, at the heart of it is a question of, does the state legislature basically have exclusive authority and power over election laws, and that includes things like redistricting, or do they have to share power with, say, for example, the state courts? So I think in the grand scheme of things, what this ultimately comes down to is who has the authority, who has control over things like redistricting that can ultimately really influence the way that state government is constituted, who composes state government, and what are the basic fundamental public policy issues that state governments will address.
Now, redistricting disputes aren't really new, right? Especially in North Carolina. Why do you think legislators decided that now was the time to take this to the Supreme Court?
Well, I think they certainly looked at the North Carolina State Supreme Court that struck down the congressional map and said, we've got a venue or a federal question by which we can get this out of state court and back into federal court. So I think that this is a real sense of, can we push the constitutional principles, the legal boundaries, to incorporate a doctrine or a theory that best aligns with the opportunity for us, Republicans, in the General Assembly to have carte blanche, to basically redistrict as we see fit.
It seems like checks and balances are, that's sort of a heightened theme these days, particularly in North Carolina. And it's not just this case, right?
Exactly. And I would point to things like the Leandro case regarding education funding. Who has the authority to determine how much money will be spent on public education? Now, it all kind of boils back to, what does the Constitution of North Carolina say? And oftentimes people don't realize how much importance state constitutions have. We're always focused kind of on federal protections, federal civil rights, civil liberties, those kinds of things. But more and more, as public policy decisions and issues are being confronted at the state level, issues like, what does the state constitution say and what does it mean, more importantly, are just as critical in terms of trying to balance who has power in our governing system.
Now, I know that you'll be listening to the arguments. What are you going to be listening for?
I think it's certainly It gives some indications if folks listen to the oral arguments and particularly the questions, most importantly by the conservative justices on the Supreme Court. But I would caution folks to be kind of circumspect in taking too much out of it. Oftentimes, the justices will bounce ideas back and forth in the form of questions, in the form of hypotheticals, not just to the lawyers, but really to themselves, to the other 8 justices. And one person in particular I'm going to be listening for to see how he reacts and what kind of questions he poses is Chief Justice John Roberts. He was instrumental in the decision of Rucho v. Common Cause, the North Carolina case that went up to the U.S. Supreme Court that basically said federal courts have no authority or power over partisan gerrymandering. But he also made a dissenting opinion in a case out of Arizona that structured redistricting to an independent commission, and he dissented in that particular opinion, saying legislatures mean the body, the representative organization. So it's going to be interesting, I think, to kind of hear what questions he poses, because in Rucho, he said it's up to the states to determine whether partisan gerrymandering is allowed. But then he said, well, in redistricting cases, it's purely the legislature that's involved.
Okay, so I want you to get out your crystal ball. How do you think the justices will rule on this? If you were to guess, just based on, there's been a ton of amicus briefs. A lot of ink has been spilled already on this case. Based on what you've read, if you had a gut instinct, what would you expect to happen?
Well, I'll first preface by saying my crystal ball cracked in 2016, and I haven't been able to get it repaired. So we're going to start off with that premise as to the start of this response. In studying the court, oftentimes the justices will seek to find a very narrow constitutional pathway to make a decision. They do not believe, the 9 justices on the court oftentimes, do not believe that they are policymakers, that they are simply interpreters of the Constitution. And they are very suspect in terms of making broad, sweeping policy decisions, generalizations on issues of this nature. So my initial gut tells me this is going to be a fairly narrowly defined reason when the opinion comes out, probably sometime in the spring. With that said, we have seen this court take on pretty significant issues like abortion in the Dobbs decision and basically overturn 50 years worth of precedent. So, in this day and age with the current makeup, I would say it's probably likely that the Republicans may fare well on this particular issue, but I'm hesitant to try and guess anything until that opinion comes out.
Well, we'll be watching. Professor, thank you for taking time with us today.
My pleasure.
That's Michael Bitzer. He's the Politics Department Chair at Catawba College and the author of Redistricting and Gerrymandering in North Carolina, Battlelines in the Tar Heel State. That does it for this episode of the WRAL Daily Download. Tomorrow, we'll hear from WRAL state government reporters for a breakdown of what happened today in the U.S. Supreme Court. I hope you'll join us. For our coverage of today's arguments in Moore v. Harper, tune into our evening newscasts and visit the NC Capital section of WRAL.com. And be sure to listen back to our other episodes on this case. Thanks for listening to the WRAL Daily Download. You can also listen to entire WRAL newscasts in podcast form. Search WRAL Newscasts in your podcast app. The feed is updated with new newscasts multiple times per day.